Okay, good morning, everybody. Welcome. I'd like to call the meeting to order. And as first order of business, I would like to take a moment of silence to remember those that have fallen since the last time we met, and ask that you additionally think of those that are suffering in the wildland fires, those citizens of those communities, as well as the public servants that are working diligently to try to contain those fires. Thank you. Okay, we've got the minutes from the meeting of June 18th. It's been moved to accept. Is there a second?
Second.
Been moved and seconded. Are there any comments, any corrections, or additions? Okay, seeing and hearing none, please vote on your screen to accept or abstain from the minutes. Is it up yet? Okay, I didn't see. What were the results?
No, and
All right, just for the record here, let's have a voice vote. Oh, it passed unanimously. Thank you. Okay. Next order of business. Funding pension plan benefits. And I'll turn it over to Mr. Nelson.
By way of introduction, at the last meeting, the board requested that we, the staff, bring a consultant in to talk with you about how pension plan benefits are funded in other plans in other states, particularly how in those instances where a revenue stream is dedicated towards funding pension plan benefits. We have today as your consultant Bob Klausner. Bob is a nationally renowned attorney in the field of public pension law. If he literally wrote the book on public pension law, it's in our library. He's counsel to a number of pension plans around the U.S. and to the National Conference on Public Employee Retirement Systems. But by way of reminder, though, he is not an attorney general. He is not a special attorney general. So his purpose today is not to act in the role of your counsel. And so with that, I will turn it over to Bob. And if there's anything else you'd like to add to your introduction, I kept it brief, not because there wasn't more to say, but I didn't know how long to go on. Bob's resume is quite lengthy, especially in the field of pension law. I've been doing pension law since 1992, and I've known Bob just about that long. I think the first time we crossed paths was when he was working as a special attorney general for the Senate,
right.
Washington State Senate, and I was working as the legal services manager for the Department of Retirement Systems. But with that, Mr. Klausner, please.
Thank you. So it was a pleasure to be here. I had a small role in actually the birth of this plan, having worked for the Senate as a consultant. I don't even remember what it was, a while. It's 12 years ago, maybe?
Almost.
Yeah, 11, 12 years ago, and then worked with bill drafting folks at the Capitol for what ultimately became the initiative, which led to the creation of this board, and then worked with the initial board to help establish operating rules and procedures to get the plan in operation. So it's always a pleasure to be back and see something that has thrived, and I took no small pleasure in reading the article that this is, the LEOFF system is the best funded plan in the United States, and out of 7,000 public pension plans, some of whom are not so well funded. It should be a great comfort to the members and to the taxpayers who are managing this plan and contributing along with the membership. This is one of the few plans where the cost is split between the members and the plan sponsors, and I think that's one of the keys to the successful funding model that you have. The only other plan in the country that I am aware of that does that is the city of Tampa, Florida. They do the same thing. They're on a 1.1 to 1. The employer puts in about 0.1% of payroll more than the employees do, and they're funded at 99% of assets to liabilities with a very high benefit. So not all plans are working that way, and we've recently been hired by the boards of trustees of the New Jersey Police and Fire Pension System, the New Jersey Public Employees Retirement System, and I'm going to be meeting with the teachers next week about funding there. New Jersey has a long history, as you may know, of not funding its pension system. The actuary would regularly say you need to put in X percent of payroll, and the legislature would faithfully put in about 10% of that or nothing. And as what happens when you run a credit card, eventually the interest overwhelms the principal, and the plan cost becomes unmanageable. New Jersey, facing that issue, adopted legislation in 2010 and 2011, which did three things. It raised the employee contribution considerably. Number two, it cut benefits for future workers, and it suspended the cost of living adjustment for retired folks, even though New Jersey has constitutional protection for pension benefits in the same way that Washington does under its own version of the Bachenhaus case. The third thing it did, which was intended to sustain the plan, was to create a phase-in of full funding, that they would pay the 100% of the normal cost, and then they would work up over a period of 7 years, paying 100% of the unfunded accrued actuarial liability, and then hopefully amortize the whole thing over 30 years, which seemed to make perfect sense. And actually, New Jersey's bond rating went up after the bill was passed. In June, on the last day of the fiscal year, the governor decided that they needed the money for something else, and he issued an executive order essentially undoing the appropriations bill and effectively suspending an act of the legislature. Without getting into a long discussion of New Jersey law, generally, governors do not have the power to set aside acts of the legislature outside of a specific veto period that governors are allowed to do with certain types of legislation. Notwithstanding that, they just didn't fund the pension system and shorted it about $1.5 billion, which only exacerbated the problem. The next day, the new fiscal year begins. The legislature adopts a new budget, which not only puts in the money, but it puts in a new tax to pay for this. If it's a burden on the public fisc, then there was a tax on wealthy folks to help raise the $1.5 billion that they needed for that year, plus the $1.5 billion that went away the day before. And the governor vetoed the tax bill, and he vetoed the appropriation. But interestingly enough, the legislation that says you shall fund is still in place. And that, I think, is the issue. When a government has a bill that says you shall fund, or there shall be an income stream that goes to a place, that's what has to happen. In fact, one of the things that was at issue in Detroit, I'm sure everyone has read ad nauseum about the bankruptcy in Detroit. We're part of the legal team for the bankrupt. Believe me, it's been a field day for lawyers, I would say. They've been the primary beneficiaries of the bankruptcy. The burn rate for money is alarming, even for me. Although the members have settled and will get, at least the police and fire will get pretty much what they were expecting, and the general employees who have Social Security, which police and fire do not, will get 96% of their benefit. But that aside, the reason that the pension funds were able to continue the payment is A, they were pretty close to fully funded, and B, part of the revenue stream that was dedicated to them was held to be outside of the bankruptcy. In other words, because it was already dedicated prior to the bankruptcy for a specific purpose, it wasn't the city's money to then place into the bankruptcy estate and then get divided by the vultures that swooped down on what was left of it. And the irony is the one who has the biggest problem is the insurance company for the bondholders. They tried to get the casino money, which was part of the dedicated revenue stream, and the bankruptcy judge said no. And they also wanted a higher preference than the pensions, because in order to save the pensions, one of the things that happened early on in the bankruptcy is when a government goes into bankruptcy, and by the way, states cannot declare bankruptcy, and I'll talk about that a little bit in a second. But I know you're a multi-employer plan, and you have municipal participants as well as other government entities that participate in the system. And Washington State does allow municipal bankruptcy without restriction. It's one of, I think, 10 states. There are 24 states that allow some form of municipal bankruptcy. Washington is one of 10 that has no restrictions on bankruptcy. But in any event, in Detroit, the most valuable asset of the city was its art museum. At the beginning of the 20th century, when Detroit was first developing as an industrial center in the United States, the wealthy folks, the Fords and the Fishers and all the people, and the Carnegies from Pittsburgh who were making the steel that went into the cars, created the Art Institute of Detroit and donated, these magnificent old masters to the museum, and created an endowment, and it's purchased art over the term. It had $5 billion worth of art, according to the appraisal. Interestingly enough, the bond insurer who wanted them to sell the art asked to have the art removed from the wall so they could send it somewhere to have it appraised, and the bankruptcy judge suggested it would be more efficient if they just bought a ticket and went to the art museum and they could take all the pictures they wanted. But in order to save the art, private industry and private foundations put up money that was needed to replace the lost pension benefits if the art would be off the table. And so the bond insurance company, his name is Syncora, thought that dedicated revenue stream was inappropriate in the context of bankruptcy, and the bankruptcy judge disagreed. Syncora will be arguing that point in the United States Court of Appeals for the Sixth Circuit next week. Yes, next week, 31st. And because there is now an agreement between the funds and the city, the funds will not be taking part in that part of the appeal. Other places that have had issues with funding was in Louisiana. Louisiana has a provision that says that pension funds, statewide funds, which are mostly made up like this, they're multi-employer plans made up of local governments but regulated by the state legislature, and they have a board established by state statute. And one of them is the Louisiana Sheriff's Pension and Relief Fund, which is also one of those plans that's up well-funded above 95% of assets to liabilities with a low employer contribution. And in Louisiana, there is a dedicated revenue stream, and it says you get certain things. The employer has to put in money according to the actuarial valuation. The employees put in 10% of pay, and there is a dedicated tax. Every government that gets service from a sheriff has to pay a piece of the action. Sheriffs are not funded. They're revenue driven. So in other words, they fund their operations entirely through warehousing of prisoners, fees paid for security in municipal and other courthouses, and so they get a piece of the real estate, the ad valorem real estate taxes off of every government. And an issue arose in New Orleans that they accidentally spent the money for 14 years in a row. It was an accident. And I'm actually a homeowner in New Orleans, and they spent my tax money too, so I was very upset about it. Particularly because I've been a lawyer for the sheriffs for 25 years, and I actually am commissioned as a deputy sheriff in Louisiana, which is probably not safe, but that's a whole nother story. But in any event, what the city said is they said that revenue stream was dedicated for other things. And ultimately what the Supreme Court of Louisiana held, not just for the sheriffs, but for the 9 other statewide retirement systems that fund constitutional officers like clerks of court and district attorneys and firefighters and other officials, it said that it's not that it's not about an appropriation. It's about a dedication of revenue stream. It says if you levy any taxes, then this sum, wherever you want to take it from, has to go to the pension system. And the city said, no, that money is reserved for other tax recipient bodies, the levies, which we know they didn't get the money either, obviously, the zoo, the parks, whatever, their art museum, whatever the various tax recipient bodies were. And the Supreme Court said that's not the issue. They said the issue is, what does the statute say? It says you shall put in X out of whatever you collect. It says we don't care what you collect, we don't care what your tax rate is, we don't care how you manage your budget, but this sum of money has to come off the top. Same thing happened in Miami, which is where I live in South Florida most of the time. And when I started as an assistant city attorney a really long time ago, in the 70s, I actually began as the police legal advisor. And I was responsible for homicides and adult entertainment. And surprisingly, they had a lot in common. Again, that's a story for a non-public meeting. But the one day I was asked by the city attorney if I knew what the pension system was. Not that the lawyers were allowed in it, but I said, yeah, it's what you get when you retire. And he said, good, you're it. And I said, what's it? He said, you're our new pension lawyer. Congratulations. And by the way, looks at his watch, he says, you're late. I said, late for what? He says, the meeting. So I borrowed a police car, and I went down to, because I was working at the police station, went down to the Miami City Hall, which sits in the former Pan American World Airways flying boat station on the shore of the ocean. And it's a lovely building. They actually used it in one of the Indiana Jones movies where the big flying boat airplane took off. It was shot there. And it's now City Hall. And so I go to the meeting, and there was a police captain who was like 20-something. And he was considerably closer to retirement. And he asked me what I was doing there. And I told him I was their new lawyer. And he said, well, the city took money. I said, what do you mean? He said, well, they explained it to me that they sold bonds for a sewer project. Except they didn't, before they built the sewers, they spent the money on something else. And so they had to build the sewers because the bondholder, that was a revenue producer because people paid a sewer fee, and that was going to generate the money to pay back the bondholders. So they needed the money, so they took it from the pension system by diverting a revenue stream. And the revenue stream was a state tax, a rebate of a state tax on casualty insurance. Florida is one of about a dozen states where every state taxes insurance premiums, every state. That's how insurance commissioners run. And it's also a price for doing business in a particular state. But in about 10 or 12 states, a portion of that tax is rebated back for police and fire pensions. The reason being, the fastest way to lower risk for an insurance company, particularly one that insures auto insurance and fire insurance, is to have the people who enforce the law or put out the fire well-trained and on the job. So it helps offset the cost to government of maintaining these public safety workforces because the insurance companies are beneficiaries. And so the city of Miami used to get about, they still do, they get about, in those days they were getting about $10 million a year from this tax, which was a lot of money 38 years ago. And still a lot of money, but it was a lot more then. And the board wanted to sue to get the money back. So I said, sounds right to me. And so I went back and I prepared the pleadings, but because I was fairly new, newly minted as a lawyer, I had to show the city attorney the pleadings. He looked at me like I had three heads. And he says, what are you doing? And I said, well, you told me we represent the pension fund, right? He said, yes. I said, well, the city took money from them. I said, they're absolutely dead on, ain't their money. And he said, but what does it say on your paycheck? And I was thinking, I once told Kelly the story. I said, I got like $6.25 an hour as a lawyer after 7 years of college, $250 a week, and I was happy to have it. But I'm doing a little better now. And and I said, well, don't we, aren't they our client? He said, yes. He says, well, your paycheck says City of Miami. I said, so? And he said, do you know about the duty you have to a client? And I still remember the ethics class from law school because it was still fresh in my head. And I said, yes. I said, we have an exclusive duty of loyalty to our client. And he said, that's right. And he says, I said, the pension fund is our client, so we have an exclusive duty of loyalty to them. He says, okay. And I said, so you're telling me the city of Miami is also our client, and we have an exclusive duty of loyalty to them too, right? And he said, now you're getting it. I said, well, what do you do when one person you have an exclusive duty of loyalty to is taking something that belongs to the other person that you have an exclusive duty of loyalty to, and it's not legal? And he pondered that question. And then he told me to go back to the pension board and talk him out of it. I actually resigned from working for the city over that one, and I ended up representing the boards in the lawsuit, which, by the way, paid for college for all of my kids and the first house. It was not a popular decision, however, because my wife was 8 months pregnant with our first. So that wasn't a happy day, but it worked out. The reason being, you can't be on both sides of these deals. As you know, as trustees, will operate under a fiduciary duty. The law is very clear in your plan, and it's clear in Washington and in the common law of the United States. These funding issues tend to arise more in places where the plans are distressed than in places where the plans are fully funded. Although there is a case now, which we've just been asked to participate in, that is in the Supreme Court of Michigan, and it involves Wayne County. Wayne County is the county where the city of Detroit is located, but while Detroit is a distressed municipality in terms of finances, and it truly is, Wayne County has some very wealthy suburbs within it, so the county government is not. And it has a defined benefit retirement system that's fairly well funded, and they have a dedicated revenue stream for a cost of living adjustment. And essentially, the dedicated revenue stream builds up until you reach a benchmark. I won't bore you with the details, but until it reaches a benchmark. When it reaches a benchmark, then you can pay. And the employer says, well, that money's sitting out there, and it's not doing anybody any good until it gets there, so we're going to use that as our contribution, and effectively wiped out the account by using, I think it's about $30 million as part of their annual contribution. And so the Board of Trustees sued, and in a very lengthy opinion, the Michigan Court of Appeals said it's not their money, it's the fund's money. And that's an important concept in my view, and I'll talk about that concept broader in a second. And the question which the Supreme Court wants to know is the accrual of money, or the revenue stream which accrues the money, part of accrued benefits? Michigan has a specific provision in the state constitution which says accrued financial benefits are a contract and cannot be diminished or impaired by any legislation. And that was adopted by the voters in Michigan 50 years ago, particularly because they were worried that Detroit 50 years ago wasn't putting in the money into the pension system, because that's when they were starting to have financial problems. And in that situation, the question is, whose money is it? And that's the question that will be settled. The issue was settled about 15 years ago in Alaska, involving the Anchorage Police and Fire Pension Fund, which I've represented since about 1990. And they're also a fully funded plan. They are closed to new members. Alaska decided that everybody should be in a defined contribution plan going forward. And they're having hiring problems as a result of it, but that's a social problem for them. As soon as everybody vested, the pitter-patter of feet headed south, because nobody goes to Alaska for the weather, I can tell you. This would be a sunny day in Alaska outside. So, although it's a beautiful place and nice people. But they had 3 plans in Anchorage, and the money was aggregated in a single investment pool and a single board of trustees. Plan A was their first plan, and it had X level of benefits. Plan 2 was a later plan created as a result of labor relations, and it had different benefits than Plan 1. And then there was Plan 3 came after that, and it had different benefits than Plans 1 and 2. And generally the benefits the scope was different. I would say they were generally equal. Some were earlier retirements, but the details are less important then. because of very good funding, they dedicated part of their oil revenue directly to the system. And so the plan was very well funded. Plan 1 had 140% of assets to liabilities. Plan 2 had 130% of assets to liability. And Plan 3, because it was new, had 95% of assets to liabilities, and it was well on its way to full funding. And the city said, well, if Plans 1 and 2 are so overfunded, why are we putting any money into Plan 3? The money's all in a big pot, and just because it's got more money doesn't mean you get more defined benefits, so what are we doing? And because they did not have a cost of living adjustment provision. Whatever the benefits were, they were granted by the municipal council, which is called the Assembly in Anchorage. And so the city said, on a bookkeeping basis, we're moving the assets, the necessary assets from 1 and 2 over to on the books to Plan 3, so now Plan 3 is fully funded and we don't need to make any pension contributions at all. Now, that was actually good for the members of Plan 3, because the only time members contribute there is when the city is also contributing. So they stopped. Plans 1 and 2 members weren't contributing already anyway, and it was very clear that the existence of a surplus did not necessarily guarantee new benefits to members. Of course, a dearth of assets would have also not affected their benefits, because they had the same kind of constitutional provision that Michigan and Illinois and New York, Arizona, Louisiana, Texas, and Hawaii have. And but the members of Plan 3 filed a lawsuit. The board was named nominally just because it invests the money against the city over whether that revenue stream would be moved from Plans 1 and 2 over to 3 without the consent of, or given something to the Plan 1 and 2 members, and ultimately the Supreme Court of Alaska said no. The biggest funding case, I think, revenue stream case that's going to happen now is the one that's going on in Illinois. As you know, or you may not know, Illinois has the worst funded pension systems in the country, bar none. And there's a very good reason. They do not put any money in them at all. They've been running on a credit card for 40 years. And ironically, their municipal fund, their multi-employer municipal fund, is completely funded. It runs like this when you have a lot of participating employers, and they all pay. The funds that are underfunded are the state plans. The state is responsible for the teacher's plan and the state retirement system, which includes the judicial plan. And there's a reason why that will prove to be important. It has been my experience that if the judges are in the plan that's having a problem, they're a lot more interested in the case. If it's not their plan, it's just one more case in front of them. One would ask, how is it that a judge can sit on a case where their pension benefits are involved? And the answer, it's called the rule of necessity. Somebody has to decide a case. And, in a federal court, you can bring in a judge from somewhere else who may not be involved in it. In fact, when I argued a case that eventually went to the U.S. Supreme Court, when we were at the Court of Appeals level, 3 of the federal appeals judges were getting benefits from the pension plan I was representing, and they removed themselves from the case. In the case of a state, there's nobody else to put in. If all the judges are in it all the way up to the Supreme Court of the state, who's going to do it? And they can't just go pick some subs off the street from somewhere, or bring in a judge from Oregon or California or Idaho to hear the thing. So because judges have determined that they will be affected no differently than any other member, that it's not a conflict of interest, and so therefore they're allowed to hear the case. And Illinois was sued by its teachers' pension fund over misdirecting revenue streams 15 years ago, and because what is happening today was easily predictable from an actuarial standpoint then. And the Supreme Court, who at that time had a different dedicated revenue stream, said, unless the checks are about to bounce, funding is a matter entirely within the discretion of the legislature. And that's separation of powers is a very important issue. In municipal government, the lines are a little blurred because sometimes the mayor is also a council member, but in a state government, it's very clear. Every state's constitution in the United States says there are three separate and distinct branches of government, and none shall tread on the responsibility of the other. And one of the things that is exclusively a legislative prerogative is the decision to appropriate money. Now, it's also the exclusive prerogative of a legislature to pass a law, which says you shall do something or not do something. And in Illinois, it says you shall fund the plan. But because they didn't appropriate the money to do that, the Supreme Court of Illinois said, we don't have the power to tread into that area of the legislature's exclusive prerogative. And so the teachers lost the case, and the underfunding of their plan continued. Illinois last year had a pension reform as if you're a believer in the rights of working people, pension reform is a terrible name because that's kind of like what you tell the cow on the way to McDonald's. It's about to undergo cattle reform. But in the case of Illinois, they cut benefits, they cut COLAs for retirees, they raised contributions, which generally are not considered an accrued financial benefit. COLAs are. And they created a second tier of benefits for new hires. And they said, we will fund the pension plan at this increasing level. They adopted a law much like New Jersey did. But they did one other thing. They waived their sovereign immunity to be sued over the appropriations question. In other words, they gave up the legal right that was recognized in the case from 15 years ago and said, if we fail to fund it, we agree that the courts can order the legislature to do so. Now, I don't even know if that waiver of that constitutional separation is even binding. I have a feeling that when that happens, that's going to be the defense, is you shouldn't have listened to us because we couldn't do it anyway. But because it treads into a constitutional thing, and you can't, an individual can waive his or her own constitutional rights, as I'm sure the law enforcement officers here well know. But one legislature can't waive another legislature's constitutional rights. And so that will be an interesting question. Illinois has one of the strictest constitutional protections for pension of anybody. On July 3rd, they issued an opinion on health care, retiree health care, saying it's absolutely protected. You can't cut it for retirees. You can do whatever you want for the people that are working, but if you're retired or eligible to retire, which is the same thing in their book, they said off limits, protected by the Constitution. So it'll be an interesting question as to what to do because it is going to involve the legislature's power of appropriation. Brings us back to where I started about New Jersey. And the question in New Jersey is they have a statute which says you shall fund on this rate. And absent a repeal of that statute, does it need an appropriation? And that's an interesting question of separation of powers because the governor he used an executive order rather than the veto. And the other question is, if one statute says one thing and another statute says something else, how do you reconcile them? And that is the job of the judiciary when you have conflicts like that. So funding streams are particularly important. New York probably had the best description of the issue. In 1990, New York was using an actuarial method called the projected unit credit method. What do you use here?
Aggregate funding method.
Okay, so you're on a level percentage of payroll or a level dollar?
Level percentage of payroll.
Level percentage of payroll. The projected unit credit is kind of like an adjustable rate mortgage. It goes up in steps, and then at the end, there's a balloon, and it's an unpleasant one. And sometimes you can reamortize it, and sometimes you can't. But New York had been on an aggregate method of funding, which was a very aggressive method of funding. And they switched to the projected unit credit because it suddenly meant the plan was funded way ahead of the schedule. So they took a line here and then used a line that went like this, and eventually it would catch up here, but it'd be a long time. And it created a 12-year funding holiday for all the participating employers in the New York retirement system, which I assume the intern that thought of that got a big bonus, and or a job, permanent job somewhere, and the sole trustee of the New York retirement system is the state controller. They have one trustee. That's it. Does all the investing. Sole trustee makes all the decisions. I mean, they have staff, a cast of thousands, but that's who really runs it. And he sued over it, saying, if you're going to cut the money out of this thing, then what good's the promise? New York has a provision that says participation in a public retirement system is a contract and rights shall not be diminished or impaired. And the question is interfering with the funding stream by altering the actuarial factors at play, messing with the money. And New York's Court of Appeals, which is their equivalent of the Washington Supreme Court, said yes, it is. And so out went the projected unit credit method and back went the aggregate method. And this issue's been repeated in a lot of places. Only two states, Illinois and Kentucky, who are 1 and 2 on the bad list of funding, have had Supreme Courts that said funding is not tied, the funding stream is not tied to the benefits. Everybody else has said exactly the opposite. And I would not expect, and now Illinois has waived that. Kentucky is also facing these issues, and eventually they're going to have to do something or they'll be out of money in 30 years. So critically to the benefit stream, in my personal opinion, I think the greater weight of opinion favors that the income stream is an integral part of the benefit in the same way that the retirement age is in the multiplier. There has also been a trend to address COLAs, particularly COLAs that are dependent on a variable event. In other words, the COLA gets paid if the fund earns more than blank. And there is a case pending in Florida right now. Actually, it just started yesterday. I have a feeling we'll be involved in it when I get home. But the question is a variable COLA, as opposed to a fixed rate COLA, still is it an integral part of the benefit? Now, there were 3 cases in 2011, one in Colorado, one in Minnesota, and one in South Dakota. They all had variable COLAs, and what the legislature did in all 3 states is adjust the variable. Now, what was interesting about the 3 of them is they had a history of adjusting the variable. It's all been adjusted multiple times. And the thing is that it had always been adjusted in a way that resulted in a more favorable situation for the workers, the participants. This one was a less favorable one because it was designed to keep money from pouring off the edge into this COLA fund when it was needed for an underfunded base benefit. And trial courts in all 3 states upheld the legislation because they said this variable COLA is really an expectancy, it's not a benefit. Now, that's contrary to a decision in California from, 22 years ago, involving all the California pension systems. We were in it for the teachers. And they got rid of a variable COLA based on earnings, but substituted a fixed-rate COLA. And what the California court said is they said a fixed-rate COLA, even though it's lower than what the variable is currently paying, is ultimately a guarantee versus an expectancy, and therefore it was a even trade. Even in states that have constitutional guarantees, generally a change of benefits where the new benefit is of equal or greater value to the old one, that change is okay because it's not a diminution. It's a substitution of something of equal value, and the test is you look at the person who is most disadvantaged by the change, and if it's still a better deal for that person, then it's not a diminution. And for example, they might, let's say, increase the contribution from the members, but increase the multiplier at the same time, so you're getting a better benefit. If it's going to yield more than what you were getting, then it's a wash, legally. And so that was okay in California, and in the Minnesota case and the South Dakota cases were not appealed. So that becomes the law. It's not precedent-setting, generally a decision of a trial court, no matter how wisely written, is not considered binding precedent except for that judge in that courtroom. But it ended the challenges in those states, so their newer, less generous variable COLA is now the law of the land in South Dakota and Minnesota. In Colorado, their Court of Appeals reversed and said it is an impairment of contract. The question is whether or not there was a public necessity to do so. And that gets into an issue that's pending in a lot of other cases about benefits. There's really two theories involved in benefit guarantees. One is impairment of contract, and the other is taking. And an impairment of contract, the U.S. Constitution says, and every state constitution has a provision that says no law shall be passed which impairs the obligation of contract. Some have, 9 states have specific ones for pension. The others, like Washington, for example, have developed that through case law. And but with an impairment of contract, the U.S. Supreme Court developed a test. And the test was, A, is it intended to be a contract? Because not all legislation is intended to be contractual. Some is. Secondly, did the law impair the contract? As I pointed out, in California, the test that they measured was what was the value of the guaranteed COLA against the variable. The year 1992 that they swapped it out, the variable was worth more, but for the last 10 years, the fixed rate COLA, they're really glad they've had it because it's proven to be far better. They would have gotten nothing. And every year they've gotten a COLA for the last 12 years. So, and wouldn't have based on investment performance. And then the test is the impairment of the contract necessary to protect public health, safety, and welfare? For example, I live in a place where they've got hurricanes and everything else. And when there has been a hurricane and the employers have suspended certain scheduling provisions of labor agreements because you needed police officers and firefighters in the scene of an emergency. And while it is, quote, an impairment of contract, it was necessary for the protection of the public. There may be times when it's a choice between the pension contract or economic survival of the employer. And interestingly enough, even in Louisiana after Hurricane Katrina, that argument did not fly. Having worked on relief in Hurricane Katrina after the storm, if ever there was a public welfare need for anything, it was there. And so that's the test on impairment of contract. In other words, there's wiggle room for government because government always has an obligation to protect the welfare of its citizens. But in order to do that, it has to show that it uses the least intrusive means possible and that this is the only alternative. And sometimes the alternative is raising taxes, by the way. And government says, and courts have said, go raise some revenue. If you want to do this. You don't have to raise revenue, but if you want to do this, then you got to do that. Or cut something else. The other thing is a taking. The best example of a taking is, I'm sure you've all heard of eminent domain. The highway department wants to build a street through your house. You know, they want to build a new street, and unfortunately your living room is right in the middle. So the government may take your house. However, what does it have to do? It has to pay you. It has to pay you fair value. And there have been times when revenue streams have been taken, and the question is, okay, if you need that, you take it, but you got to pay us the fair value of what you took in some other fashion. And those are the two legal issues that generally arise in the context of pension funding. There's very little jurisprudence on the taking. There's a lot of jurisprudence, meaning court decisions, on impairment of contract. And the issues will remain in flux for some time. There's federal lawsuits now in Florida, in Ohio, in Texas, in Louisiana, in Michigan, in Connecticut, in Rhode Island, Maryland, Texas, California. I'm sure there's some other, Arizona, New Mexico, and Colorado. It's busy out there. And a lot of it was driven by the economy. And, you know, I was talking before this thing started, and I said for many years with this work that we did, we labored in obscurity, and it was just fine. It's been extremely exciting the last 7, 8 years, probably more exciting than it needed to be, and I would be happy to go back to boring. Fortunately for you, things should be boring because of your funding status, but issues arise, and I'd be happy to take questions.
Any questions for Mr. Kloster?
I stunned him into silence.
Thank you, Mr. Chair. Going all the way back to New Jersey, what you mentioned at the beginning, I think you said Chris Christie vetoed this, but you mentioned that New Jersey has a case law similar to Bachenhaus here, and that they cut benefits. Is that being appealed?
Yes, the unions are appealing it. The membership and the unions. What they tried to get was they started filing the lawsuit, and they sued, and they lost in a case involving where the first thing that they tried to do was to get an injunction. They tried to get an injunction against not putting in the money. Generally, the judge said no, and actually, I think the judge was correct for this reason. She didn't rule on the merits of whether the benefit could go up or could go down. What she ruled upon was, they said, with an injunction, injunctions are to prevent irreparable harm. Irreparable harm is if they're about to cut down a 3,000-year-old tree in your front yard and you can't replace it. There's no way to replace it. An injunction over money, you can always rub green on it later and it heals. So that was really the narrow issue that she decided in a 63-page opinion. You can imagine if she'd have gotten to the merits. That is being appealed, and that's currently in the appellate division. The same day that the trial judge ruled against the injunction, the New Jersey Court of Appeals said that health care for retirees is a constitutionally protected benefit, and you can't cut it. So they have two opinions now, and that this case over the benefit cut tied to the funding, to the additional funding is what's now moving its way to the Court of Appeals. For the funds, the issue is different. I just finished doing fiduciary education for all the retirement systems in Louisiana, the 4 state systems, and several of the statewide systems attended as well. And because they have a law, by the way, that requires 8 hours of continuing education for trustees every year, and I think that's a great idea. You have to have 2 hours of legal, 2 hours of actuarial, and because the boards there do the investing, they have to have investment as well, and 1 hour of ethics. Under the state, they have I know it's Louisiana, but they still have a very strict ethics law, surprisingly. And the cases, the violations are just as exciting as the law, let me tell you. It's creativity at its highest. But the issue for the funds in New Jersey is different than it is for the members. The funds have a duty to go get money. As the trustee of a trust is always required to marshal the assets of the trust. An executor of an estate would do that. If they found that somebody owed the dead person money, they got to go get it. And if there is an unpaid contribution, so you have multiple employers in your plan, if there was an employer who hadn't paid for whatever reason, as we do see from time to time in multi-employer plans, the board's got to go get the money, and even through the use of legal means if necessary, power of the judiciary. But it's different when benefits are affected. Benefits are not. The administration of benefits is the job of the board. The making of the benefits is not. If a government passes a law that says we're going to change the retirement age from 20 years to 22 years, the board should administer the plan as written by the legislature unless the law is later struck down. If, however, you had a recalcitrant employer that wasn't sending you money that statutorily is directed to go to you, then that could be the board's interest to do so. The members could also sue, saying that the underlying value of the money is an accrued benefit to us, because what good is the promise without the dough, and therefore bring suit in their own name. We had a case that went to the Louisiana Supreme Court last year, and the legislature had all the state plans had been reformed between 2010 and 2013, and they'd all cut benefits for future workers, and they'd raised employee contributions, and they have a constitutional protection as well. And it had resulted in a considerable decline in the state's contribution to these 4 state systems. Notwithstanding that, the governor said we're going to engage in pension reform. You know, you get a guy who's running for something else, and they always want to fix it. So he said we're going to close the defined benefit plan, and we're going to create a cash balance defined benefit plan for new hires. And a cash balance plan is something that funds like a DC plan. Everybody puts in a certain amount of money. The account gets a guaranteed rate of return every year. But then when you get to the end, when you're eligible to retire, you take whatever the sum is in that account and you annuitize it, and that's when it turns into a DB plan. If you outlive your account balance, you still get the benefit, but it's actually costlier than a DB plan. And the actuarial note said that it was going to cost millions more. But philosophically, eliminating the DB plan was the issue, apparently not the money. Problem is, there's a provision in their state constitution, as in many state constitutions, that says if you have a bill about money, you need a supermajority to pass it. If it's a bill about pensions, because a lot of places were sensitive in years past where benefits were granted and nobody worried about funding them, and then some future generation of taxpayers ends up with the cost, and the intergenerational shifting of responsibility is generally considered a bad thing, not only for government finance purposes, but socially as well. I mean, the people who are getting the service ought to pay the wages, which is what pensions are, deferred wages, to the people who served them, not take the service and stick your kid with the bill. And the bill didn't get a supermajority. It just didn't. It fell 5 votes short in the House. And I don't care how many times you divide up 100 by 2/3, you're just 60 votes isn't. You can divide it up as many times as you want. It's not enough. And ultimately, the Supreme Court, by unanimous vote, threw it out. And they said, but here's the reason why we threw it out. We threw it out because you didn't follow the law. Follow the rules. If you really want this new plan, the wisdom of the legislation is not the concern of the judiciary. We think it's a stupid idea, basically, but that's not our call. It's a legislature's call. And that's not in the opinion. That was at the oral argument that came out. Ultimately they said, courts call balls and strikes. And that's what they did. So you got to follow the rules. And what I think happened in New Jersey is they didn't follow the rules. It says you shall fund X. So that, to me, means if you adopted any budget at all, then that money's got to come off the top. Now, if they repealed the bill that said you shall fund at this level, that'd be a different story. That's also a different lawsuit, but it'd be a different story. But as long as the obligation to fund remains, I'm not sure that a specific appropriation related to it is necessarily required. But that's ultimately a question which will be decided by the Supreme Court in New Jersey, I am sure. Did I answer your question? Okay, good, because it was a really long-winded answer. Probably could have just said yes.
Question.
Okay.
Well, we know that you are on a tight schedule, Mr. Klausner, so thank you very much for your time.
It's always a pleasure to see everybody here and to have an opportunity to serve as a consultant for you. And I think it's a great tribute to the hard work of the board and the good work of the State Board of Investment, and the funding discipline that has really been unaltered here. And that has been your key to success, and I hope that will remain the case.
There are 4 of the original trustees that are still here with the board, and remember your contributions in the establishment of this board. So thank you very much, and it's always a pleasure to have you here and educating and informing us. Thank you.
Always a pleasure. Thank you. And as I said, I prepared an outline with a lot of these materials in it. I also gave you what's going on in Canada. I recently did some work for some of the funds up there, and it's a very different situation. They are cutting benefits up there, but the legal picture is a lot different. So I put that in because I thought it might be of interest. Thanks
Thank you
again.
again. Why don't we take about a 5-minute stretch, restroom break, coffee break, and we'll reconvene in 5 minutes. Or do we go to executive? Let's take 5 minutes, and then we will be in executive session. Do you know how long?
Be, depending on questions, but
So we'll probably reconvene at this point without any changes. We'll reconvene at 11:15. So we're going to take a 5-minute break, go to executive session, and be back in here at 11:15. Okay, we are in recess. Okay, we'll reconvene the meeting. Do we have to give a report on what we?
no.
Yeah, the executive session was over. We just discussed possible litigation, no action taken. And so at this point, we'll have Lisa Wan from the Office of the State Actuary.
By way of refresher for the board members, at the last meeting, Lisa and Matt Smith presented the preliminary results of the actuarial valuation and also the demographic experience study. Lisa's here today to just give an update on where that stands now and answer any questions that you have. With that, I'll turn it over to Lisa.
Thank you. And this is a follow-up presentation to the presentation from last month. And in addition, a few other items that I've been asked to speak to today. So I'll go over the any changes from the preliminary results that were presented last month. Spend a little bit of time on some additional information on the duty disability assumption, and that came in response to a question from Chair Fox last month. Then go over the contribution rate and budget impacts for the new valuation, including the decisions before you for today, which I believe Ryan will be going through as well this afternoon, and then a brief discussion on administrative factors that I was asked to speak to as well. So overall, no changes to the preliminary results that we presented last month. The independent actuarial audit performed by Milliman, who you will hear from after me today, found that our demographic assumption updates were all reasonable. They did suggest an improvement to our methodology when we study mortality. We looked at that, agreed with them that it is an improvement. It did not change the results for this study, so we left our current methodology in place, but we'll be implementing that new methodology in the next experience study. And at the time that I prepared this presentation, they had not found anything with the actuarial valuation results that were in any way material. They did discover one thing with the entry age normal cost methodology that we are still looking into, and they are suggesting, and we are planning to implement that in the next valuation should we agree that that methodology makes sense. So just to go over kind of quickly the summary of the assumption changes that we presented last month, again, that have not changed. The mortality, we have lowered the mortality rates to reflect longer lifespans, generally going from, and including projected improvements in mortality, moving from 50% of scale AA to 100% of scale BB, and that increases short-term costs and was the most significant assumption change for this experience study. Both retirement and termination rates have been updated, reflecting later retirements and fewer terminations, and both of those decrease the short-term costs. Made adjustments to the disability rates and the percent duty disability, which I'm going to go into more detail, the percent duty disability in several slides right after this. But no changes were made to percent total disability or catastrophic disability assumption, and that increases short-term costs. The service-based salary increases that we talked about in more detail last month, lower assumptions in early career, but then extended the salary scale in later careers. I believe it was cut off at 20 years of service, and we've extended that. And that increases short-term costs. And then there's a whole host of miscellaneous assumptions that are very small, but in total increase the short-term costs. And we will have a full, very extensive experience study report available for you in the fall that will go into great detail of every assumption, including details of every one of those miscellaneous assumptions. So spending a little bit of time on the disability benefits, and this was the question that Chair Fox asked last month regarding the assumption for duty disability for firefighters. So before I get into that, just want to give you, we've used this flow chart before just to kind of help you understand. LEOFF 2 has more detailed disability benefits, and the benefits vary at each of these levels. So basically we start with rates of disablement. So overall, what is the probability or chance that someone disables at a particular age? From those, we then determine how many or what percent are duty-related, what percent are non-duty related. Of the duty-related disabilities, what percent are catastrophic or total, in other words, can't perform any work, versus what are considered occupational. So that's the structure of the disability assumptions for LEOFF 2, and it's structured that way because there are different benefits at each of those levels. And we're going to spend our time talking about the percent duty, which was the question that was asked last month. So prior to the expansion of the occupational disease definition in 2007, the duty disability assumption was developed for the plan as a whole. Once that expansion of that definition came in, it was determined that we would expect a higher percent of firefighters to have duty disabilities compared to police. So the development of this duty disability assumption was then split by occupation. And the assumption was 100% of firefighters' disabilities would be duty related. And on the police side, it would be a higher percentage at the early ages, 95, and scaling down to a lower percent as they get older, 70% at age 55. So that's how it was structured after that expansion. And so we've only got a short period of time. The earliest we would have seen any experience under those assumptions would have been 2008. So for this experience study, the maximum we have is 5 years of experience. So it's very small. But what we are seeing is, and this it goes along with what Kelly Fox thought, is that we're not seeing 100% firefighters. We actually are seeing a little lower, but we're also seeing more police than that assumption of 95 scaling down to 70. And we'll look at the actual experience in a minute. I have all that for you. Right here, we can see that for the firefighters on the left-hand side, we are seeing 58 of 68, so approximately 85%. Now remember, that includes some periods where we weren't where the occupational disease definition hadn't been expanded yet. So we are seeing one or sometimes two per year that are not duty disability. On the police side, overall 79%. And again, remember that assumption starts at 95, scales down to 70, and overall we're seeing 79%. So the disability assumption is developed by occupation, but then it gets blended and applied to the plan as a whole. So although we're assuming in the development of the duty disability assumption that 100% of firefighters are duty disabilities, that doesn't get applied to the firefighters in the plan. So it gets blended with the assumption of the police, and we have one set of rates that get applied to everybody. Does that make sense? And that current assumption is a good fit overall to the plan. So even if we did adjust that 100% firefighter, we would then have to go in and adjust the final rates because the final rates are a good fit for the plan. However, as I mentioned, we do have a very small amount of data since we changed that assumption, and at the next experience study we will have an additional 6 years. So at most we had 5 years. Next experience study will have an additional 6 years, and at that time we will revisit whether we should even have it split by occupation and what that blended result should look like. Yes? Correct, at the experience study. And we don't change that every year. It's only at the experience study. And I'll actually go through that quick little calculation that will clarify that. So this table shows the actual assumptions. So the old assumption for duty disability and the new assumption. And you can see that, for example, at age 20, the assumption that was in place was 97.15% of all members at age 20 that disable would be duty disabilities, and that has been increased to 97.25, and that reflects, Mark, the change in the percent of the plan that's firefighters went from 43 to 45. So that calculation really represents 100% of 45% of the plan plus 95% of 55% of the plan gets us to the 97.25. That's how they get blended together, and then this set of assumptions applies to everyone in the plan. And it is a good fit for the plan, as you can see in this table. So when we apply those duty disability rates to the entire population, you can see that we have a 95% fit. So under the old assumptions, was expecting 142 duty disabilities over that period of time, and the actual were 135. Now with that small increase in the assumption, it's 143 versus 135. So it's still a very good fit overall. So any questions on the duty disability assumption and development? Okay, so we'll move now into the actuarial valuation results. And as a reminder, nothing has changed since the last month's presentation. The funded status for the plan has dropped from 119% to 115%, and in most part because of the reflection of the improvements in mortality has increased the liabilities, the value of earned benefits for the plan. Also just wanted to point out that the deferred gains and losses for the plan have dropped from $581 million to $225, and that will drop quite a bit. We've just found out that it looks like the investment return is around 17% for this last fiscal year, so that'll be very different next year. The resulting contribution rates from the actuarial valuation, we've presented these basically in, I believe, the options that are before the board today. Currently, the board has adopted the level contribution rates on the far left through the 15-17 biennium. So, in fact, you don't have to make any action today. You could continue with those adopted rates, employee rate of 841. You also have options in front of you if you would like to adopt a different set of contribution rates, and we've kind of laid them out in the various options available before you. Prior to the experience study, so before updating all of the demographic assumptions, the employee 100% entry age normal cost rate would be 8.60. And then after the experience study, if you went back to your longer term funding policy of 90% entry age, that employee rate would be 797, or if you stayed with your shorter term funding policy of 100% entry age, it would be 885. The budget impacts for those different contribution rate options are presented for the next 2 biennia only. We don't provide long-term impacts for assumption changes because they are updated every 6 years. And really the actual cost, we've talked about this a lot, the actual cost of the plan are what actually happens versus, what the assumptions expect to happen. So the 2-year biennial or the 2 biennium budget impacts for the plan. On the left, we're showing before the experience study with 100% entry age, and then we show the 2 post-experience study options. So if the assumptions weren't updated and the board stayed at 100% entry age, the total employer budget impact for 15-17 would be $7 million. Moving to 90% entry age after the assumption update would be savings of $24 million. 100% entry age would be a cost of $34 million, total employer. And they increase slightly for the next biennium. And that's mainly changes in salary, expected salary base. So the contribution rate decisions before the board today, again, no action would be maintaining the current rates through 15-17 that you've already adopted, or you could take the 90% entry age from the updated actual evaluation report or 100% entry age from the updated valuation. And all of those options, from our perspective, are reasonable based on funding policies adopted by the board. So my final slide is to just give you an update on administrative factors. So administrative factors are factors used by the Department of Retirement Systems to adjust members' benefits should they select any kind of optional form of payment. So for example, when a member goes to retire, their benefit is based on their lifetime. If they would like to provide a benefit for their spouse should they predecease their spouse, that's a joint and survivor option, and factors have to be applied to reduce their benefit because now it's paid over 2 lifetimes versus 1. And whenever assumptions change for the funding of the plan, we need to consider whether the administrative factors should be updated as well because they use those underlying assumptions in the development. So once all the decisions have been made from the board on contribution rates, which would include what you've adopted as far as demographic assumptions, then we will begin the process of working with the Department of Retirement Systems to update those factors. And I want to let you know that DRS implemented a standardized adoption schedule where it allows for both public review and communications to members so that they are aware that the factors are going to change. And it is a 1-year process from the time they receive the new factors from our office to where they are then implemented and applied to members' benefit options. And their goal is they adopt those factors on an October 1, so that's their implementation schedule. So in order for that to occur, that 1-year time frame, it's not possible for us to have all of these factors ready for them by this October. So they wouldn't be, we don't expect they'd be effective until October 2016. And that's everything I've prepared for you today, and I'm available for questions, and I will also be here for questions as Ryan presents, again, the options available to you today.
Thank you, Lisa. Are there questions for OSA before the auditing actuaries make their presentation?
Lisa, I just had a question. Is that you said all these options are reasonable based on current funding policies, and just taking the bookends, if we were to drop it at 90% and we got it wrong, or we overdid at the 100% at those different rates, when would we be able to change? If we change our policies now, when will we get to touch this again to make sure that if we were too low or too high that we would be able to adjust this? Is it next year? When would we get that information again?
Well, We go through a typical rate setting process every 2 years, but that doesn't preclude the board from making a decision at any time, really.
Yeah,
But the process in statute is a 2-year process.
The decision that's made by the board will be incorporated into the state budget for the next biennium and into local government budgets for the next year. Statutorily, the board can make a rate adoption decision at any time. If you do it kind of out of sequence, though, then the implementation of it becomes problematic. So, for instance, if next year the board were to vote to increase rates, then it would have to roll into the state's supplemental budget process. And for local governments, they may have already set their budget for the year, and then if rates change mid-year, they have to make their own course corrections, if you will. But the board has the statutory authority to adopt rate changes at any time. It's just by practice you have adopted it sort of on the same timeline that the state uses, so that there's sufficient time to roll it into the state budget.
Any other questions? Okay, thank you, Lisa.
Yes. Next up, the actuarial firm of Milliman spoke to the board at the last meeting about their role in auditing the actuarial valuation. Every 2 years, when the rate-setting valuation is performed, the Pension Funding Council and the LEOFF 2 board partner together to have the valuation results audited by an actuarial firm, an independent actuarial firm. This year, Milliman was chosen to perform that audit, and here to speak to the results of that audit are Mark and Daniel. With that, I'll turn it over to you.
Steve, it's a pleasure to be with you again. Today we will be continuing and finishing our presentation, which we began with you last month. The slides from last month are still there. We are not planning on going over the same slides with you a second time. We are planning to go over with you the new slides, which will summarize our results, our recommendations, and some additional information which we've added on the mortality assumption. So to review, the purpose of our audit is to review OSA's work and confirm that the results of the valuation and the recent experience study are reasonable. The scope is a full independent replication of the actuarial valuation results, which we've done. We've gone through all the same processes independently, and a full independent review of the experience study. So what you need to know is that OSA's actuarial work is reasonable and appropriate. We have a good match on the liabilities and the contribution rates, and the assumptions being used are reasonable. Our recommendations are to make no changes to the 2013 valuation, although we do have some changes in methodology, which Lisa already referred to, which we think should be addressed for the next valuation. So what we do is we look at all the independent parts of the actuarial valuation. Last time we talked to you about the data, we received the data from DRS, just like OSA, and confirmed that the way that OSA had processed the data was correct. We similarly looked through all the asset calculations and confirmed that they were correct. We have now finished our review of the assumptions and confirmed that they are reasonable. We have, in addition, added the benefits, the fourth element of the pieces of the puzzle, and we will show you that the liabilities and the contribution calculations resulting therefrom are also very close to what OSA had calculated. So I'm going to pass it over to Daniel with that.
Thank you, Mark. And so as Mark referred to, we take the puzzle pieces. We took the puzzle pieces for data and assumptions and plan provisions and used those to project all the expected benefit payments into the future. And then we took those payments and we discounted them back to the present using the investment return assumption of 7.5%. And the result, you can see in the second to last line, the total members we match at $10.3 billion, and that precisely matches, or it matches the Office of the State Actuary's calculations quite well. And then in addition to that, we took a look at the projected unit credit accrued liability method, and what we found is that we had a good match there as well, and that's used for determination of the funded ratio. And we also looked at all the little pieces, but rest assured that we matched well. So then we took one last piece of the puzzle. We took the assets along with our liability calculations, and then we calculated the aggregate normal cost rate, which isn't actually the one that applies, but we did measure it, and we found that we had a close match. We were at 13.93, whereas the OSA was at 13.96% of pay. And then finally, we looked at the entry age actual cost method normal cost rate, and there we matched even better. We were at 17.71% in total versus 17.70%, and then we've broken that out 50%, 30%, and 20%. And with that, I'll pass it back to Mark.
The only notable recommendation we have, Lisa already referred to, it's the calculation of the entry age. This only applies to the entry age normal cost. Currently, the entry age is being determined by taking current age minus a truncated service. So if you will, an example, if the current age of the member is 40 years and their service is 10.6, truncation is when we round down. So the 10.6 years would be rounded down to 10 years. So we would take someone 40 years old, subtract 10 years of service, and we would get that they are 30 years old at entry. Because remember, in the entry age cost method, we spread the cost over the entire career of the member from entry to termination or retirement. We are recommending that OSA consider a change in the methodology to, instead of rounding down the service, to round to the nearest year of service. This would change the entry age normal cost, lower it actually by between 2 to 3%. We do not see this as a cause for concern. It's a small impact, and what OSA is doing, their method is conservative, but we do recommend changing the method next year, and as Lisa reported, OSA is looking at that. We have some other changes that we're recommending concerning the methodology for determining the experience or the assumptions in the experience study, and as Lisa said, their OSA is also looking at that. Those are detailed in the audit report, and none of them cause a material impact. In addition to the new recommendations, we also reviewed all of the recommendations by the prior actuary, or the prior auditing actuary, and Daniel is going to report to you on those.
Correct. So we did look at the recommendations that came from the prior auditing actuary, and we looked at them independently, and then we also discussed them with OSA staff, and we found that most were implemented. One will be implemented with the next valuation, and the rest were immaterial. We'll be happy to discuss those further, and we will discuss them further in the report that's forthcoming. And unless there are questions at this point, I think we're going to skip ahead to slide 17.
Yeah, we're going to talk a little bit about the mortality assumption, both because it's the most important change in assumption and because we've done a little additional research since last time, perhaps because actuaries just can't resist talking about the mortality assumption. At any rate, I am going to review just what we went over with you last time, just to set the stage. You'll remember there's two parts of the mortality assumption. There's the base table, which has to do with what is the probability today of living another year. And then there's the improvement scale. It's generally recognized that people are living longer. The question is, how much longer will they be living in the future? So we reviewed the base table recommended by OSA. We had multiple discussions with them, and as Lisa said, we made one recommendation for a change in the method of looking at it next year, which OSA is adopting. Found the base table very reasonable. And then we looked at the improvement scale, and the improvement scale is where it becomes a little bit more of an art because, as I said, no one really knows how much mortality is going to improve in the future. But we've taken as close of a look at it as we can. OSA is recommending scale BB. We believe this is a very reasonable assumption. The Society of Actuaries' most recent report on this states that scale BB was composed using Social Security data from 1950 to 2007, which is the most credible and the largest body of data about mortality improvement available, and that it was tested to be consistent with two large public plans. So those are good indicators. As I said before, the thing is that no one really knows how rapidly mortality will improve, and that means that there are many reasonable assumptions. We have done some further research since the last time we met with you, which we actually received data from the Social Security Administration, compared it in detail to scale BB and scale AA. We'll show you the graph in a moment. And what we found, not surprisingly, was that scale double B, because it was consistent with what we'd already read, was that scale double B is lower than the improvement over the last 10 years. I'll show you the picture in a moment, 1999 to 2010, but larger than, it shows greater improvement than what was experienced in the 90s, the 10 years preceding that. We also compared to the large public retirement systems, which we thought might be the neighbors, so to speak. And we found, well, first of all, let's remember that what OSA is currently using is equivalent to half of scale double A being used generationally. And when I say generationally, that means that we assume that each generation, future generations, are going to live longer. Well, systems which are using full scale double A generationally are Oregon, Idaho, Seattle, Tacoma, and Utah. Wyoming has moved to scale double B fully generationally, although they're one of the few that have. Most systems haven't moved there yet. And then we looked at some other states, but they have static mortality projections. It's very difficult to compare a static projection where you're assuming the same lifetime for every single person, regardless of when they were born, to a generational projection. And just to point out which states those are, those would be California PERS, California teachers, Montana PERS, Montana teachers, Colorado. Well, this is where it gets fun for the actuary, because we look at the graphs. Actuaries love to make graphs and look at data, and so I want to take a couple moments describing these to you, because we have a lot of things pulled together on these graphs. First, point out that what we're looking at here is the ages 60 to 95, because those are the ages which are most important in terms of mortality. And when I say important, I mean important to the liability, which the actuary is calculating. And then, of course, the y-axis here is the rate of improvement in mortality. The shaded areas show scale double A in blue and scale double B in tan. So I'm going to be focusing on that tan shaded area, which the top of it is right at 1.5%. So that's scale double B right there. If we compare it to the Social Security data from the last 59 years, from 1950 to 2009, we'll see that for females, or for males, excuse me, right now we're looking at males, scale double B is somewhat higher. However, if we look at the last 10 years, from 1999 to 2009, in the dark purple dots, we see that scale double B is somewhat lower. Now, one of the main takeaways I think is interesting here is actually that if we go back 10 years before the last 10 years to the 90s, we see that mortality improvement was much lower. So just my point here is that just over a 10-year period, comparing the 90s to the next 10 years, we see a large, over 1% difference in the rate at which mortality has increased, which is back to my earlier thesis of no one really knows how fast mortality is going to improve in the future. And yet it's very important to make a prudent assumption which sets aside enough liability for future mortality improvements. That's, to some extent, that's the dilemma which we all find ourselves in. The one other thing that I've not pointed out here was that the first 50 years, the Social Security data went all the way back to 1900. So I put the first 50 years, 1900 to 1950 on as well, and you can see that mortality improvement was happening back then too, but it was not as rapid as it was over the last 59 years. Well, that's the males, so we look at the same information for females, and we see a similar story. Now, here, the tan squares, which show the last 59 years of experience for the Social Security Administration, are very close to scale double B. Again, the blue dots, which represent the most recent 10 years, are larger. Mortality improvement has been happening more rapidly in the most recent 10 years. And again, there is a large difference in the rate of mortality improvement in the 10 years before that. So we've got two consecutive decades here. If we go back to the 90s, in that 10-year period, the improvement in mortality was much lower. Over a 1% difference in the rate of mortality for two consecutive decades. Again, the bottom line of all this, we took a closer look, but it really doesn't change our findings from what we told you last month. We believe that scale double B is a very reasonable assumption for future mortality improvement. So with that, I'm going to skip all the way to the end of the presentation. Lisa did a very thorough job of going over the assumptions with you. And that takes us to the summary. Our recommendations, therefore, are to modify the methodology used in the entry age in future evaluation to calculate the entry age, to implement some method changes pertaining to the setting of assumptions, to modify the value of the OPEB benefits for future evaluations. There's just a couple things that were the prior auditor brought to attention. They're not at all material, but those could still be taken care of. and I think OSA is looking carefully at that. So in conclusion, you should have a high level of confidence in the numbers which OSA is producing and the assumptions being used are reasonable. If you have any questions, we'd be happy to answer them, including all the slides that I skipped, many of which we went over last time.
Are there questions for Mark or Daniel?
I just have one question. It's actually not about the audit. On slide 18 at the bottom, you put private plans use static projections, and you said that's not a very. I just find that interesting. I guess you said that's not the most thorough or useful use, even though some states look like they use it too.
There's a couple of. I'll see if I answer your question. If I don't address it, give it send it back to me. You can calculate the same liability essentially with a static projection. So what you do is you project mortality forward, and for some people you're actually assuming that they'll live longer than they really will, and for other people you're assuming that they won't live as long. I mean, somewhere in the middle. There's a couple of drawbacks with that. First of all, of course it's not as theoretically elegant, but my concern is that when you come 6 years down the road and you update the assumption, you're going to have to adopt something which shows that people are living longer, and you have a discontinuity, a step, if you will, in your liabilities. Suddenly your liabilities step up in the future, whereas if you're using a generational assumption, each year you're getting a slightly younger, they're not actually younger, but a group of people who are born slightly later who are projected to live longer, and each year you're making an appropriate adjustment for the mortality of the current group. You don't get those same types of discontinuities. Now, I know you're interested in the entry age normal cost, and forgive me if I'm going too far here, but similarly what you'll see is that each year there's just a small creep up in the entry age normal cost because we're looking at a group of people who are projected to live just a little bit longer each year. But as an actuary, I would prefer to look at an assumption which each year reflects the expected mortality from the specific group and creeps up very slowly than an assumption which each 6 years gives me a stair step. So I hope that answers your question. The IRS isn't as concerned about that. So,
although they are reviewing that, right? I mean, that could change, but
it could.
That's some have discussed that, but nothing has changed at this point.
I think one of the reasons that the IRS was reluctant to do that too is that it takes a somewhat more sophisticated valuation setup. The actuaries wouldn't have been able to. Any other questions?
Thank God our actuaries can handle all that.
Yes. Quite capable.
Indeed they can.
Quite capable.
All right. Thank you, gentlemen.
Thank you.
At this point in time, Ryan will bring forward the options that the board has before you as far as rate adoption. And if you have questions for Ryan or for the actuaries, they're here. They're still available to answer those questions. And but I'll let Ryan kind of present what those options that Lisa mentioned in her presentation earlier, kind of remind you of what those options are.
Thanks, Steve. Thanks, Mr. Chair, members of the board. For the record, Ryan Frost, a research analyst for the board. And as Steve said, this is just more going over the options of what you guys have. I'm going to go over a couple other things. You have the statutory duty to set rates, as well as a few of the goals and achievements of the first strategic plan that the board had, as well as some updates to that before I go into the options. So the board is authorized to set rates, and usually, as Steve mentioned, we set the rates every even number of years, but those can be adjusted at any time. So in the first strategic plan, 2004, the board really wanted to maintain 100% or better funded status, as well as have predictable increases in contribution rates. After the recession hit, we added a couple more parts of that plan to have a projection of a fully funded status through 2017, as well as have a level increase of rates to fully fund the plan. With that, I'm going to skip through a few of these and just go to the chart with the options on it. So that leaves you with 4 options. One, which you wouldn't have to take any action on, is to leave the rates how they are. Option 2A would be to have 100% of the entry age normal cost before the updated assumptions are enacted. Option 2B would be to have 100% of the entry age normal cost after those mortality and other assumptions are enacted. And the option 3 would be to have to take the aggregator 90% floor of the entry age normal cost after the updated assumptions. And with that, I'd be happy to answer any questions.
Any questions for Ryan? David?
I think in your prior presentations you had given us the history of what we've done with rates, and I thought the last time we set rates we actually decreased them just slightly because of the revised assumptions. Was that? I'm trying to find out where that table is. And
That's correct. Your memory is correct. The board has had two sort of policies in place during the roughly 12 years. The first policy that the board adopted was a step up. At the time the board was created, the rates that had been established for the plan by the legislature were significantly lower than the entry age normal cost, and the board adopted a 8-year plan, if you will, to move those rates up to where they match the expected cost of the plan. Since that time, you've sort of had a second policy, which has been historically to match the rates that you've adopted have matched 100% of what the normal cost is. That would be equivalent to the option 2B on this table. Sometimes that has resulted in an increase in costs. 2 years ago, it resulted in actually a slight decrease in costs. The normal cost is fairly stable. Typically, the assumption changes are the only thing that affects that. 2 years ago, there was some data improved experience that resulted in that slight change. You'll see here there are two things in play. One is some more updated experience. That's kind of what's responsible for the increase, if you will, from 841 to 860. And then there's the actual impact of the new assumptions in the experience study, and that's the second piece from the 860 to 885. I don't know if that answers your question.
And for discussion purposes, I'm hoping to hear from all of us because this is a key point. So I'd like to make sure we hear from everyone. It just seems option 3 is off the table. That just seems not what it's not part of our policies. Hasn't been what we've made decisions. It seems like we have new information from these assumptions. We only do this every 6 years. It seems like option 2A or 2B is a reasonable moving forward, and I'd love to hear from other board members about their thoughts. I do think we need to take action because we have new information, but just kind of finding out what other people's opinions are. I'd love to hear from more board members about their options and concerns about these things.
Okay, Mark?
Yeah, I guess just as a way of a procedure way of moving that along, I'd like to make a motion then that we maintain our current rates for the 2015-17 biennium, and then for the biennium after that we adopt 100% of the entry age normal cost after the new assumptions.
Okay, that's a motion. Is there a second?
I'll second that.
Okay. All right, so discussion.
Just to speak briefly on that, I think that's reasonable. I think that there are some budgetary constraints, and leaving the rates as they are through the next biennium is certainly reasonable and falls in line with what the actuaries are recommending. I think the biennium beyond that, I think we really do have at that point a responsibility to adopt the other method in order to take into account the changes in mortality, the improvements in mortality.
Okay, is there further comments? I had one question, and this for Lisa. The MP 2014, will we have those results within the next couple of years? Which is, recollection serves me, that will be a more accurate or another step in finding accuracy in the rates of mortality?
Right. There's two components to that. There's actually the 2014 base table and then the 2014 projection table, and I believe those are supposed to be ready by the end of this year. So we could be bringing that to the board and talking to you about that next interim.
As I recall, we didn't know if it would be from an experience perspective, better or worse as far as rates. It might be an increase, it could be a decrease. We didn't know at that time when we talked about scale double B.
I believe we looked at implementing the MP and RP 2014, and I could get back to you on that. I think it might have increased rates a little bit over scale double B, but I'd have to get back to you because I'm not 100% positive.
Okay, thank you.
But I would say that scale BB was intended to be the interim to model that. So.
Okay, thank you. Okay, any other questions?
Not a question, just comment.
Okay, go ahead, Pat, and then Jeff.
I speak in favor of the motion because it carries on with our policy, being consistent with what we've done in the past, especially keeping, extending it so we're keeping up to date and have the latest figures.
Jeff?
Well, thank you, Mr. Chair. I'm going to echo what Pat's saying on this. This is one of the reasons that we are the best funded active state retirement system in the country, is because everybody agrees that when you take the very early end of the setting up the present value of an annuity and you adequately fund it, there's no surprises down the road, and you don't have those exponential catch-ups later in the game that we've avoided so far here. That we've been a model for the rest of the country, and is one of the reasons that our executive director has been invited to speak many different places throughout the country, is because of this specific type of application behavior here that we're exempling today, about just being conservative and prudent in our policy in the base years, when it's sometimes hard to do so.
All right, thank you. Paul?
Well, I'm in favor of the motion also. I represent fire commissioners throughout the state who really haven't given me any feedback on this, but I do know that a lot of them are still struggling with their budgets, and things are starting to improve, and I think for the next 2 years, keeping the rates the same is probably a wise thing. It will help everybody, help the employers and the state also, but we do need to look at the future, and going to option 2B in 2 years down the road, I think is a reasonable route to go, and I think it'll be accepted by the employers and more likely by the state by then. So I'm in favor of the motion.
Okay, thank you. Okay, seeing no one else. Oh, David?
I just wanted to echo the comments I heard here. I appreciate the conversation. I'm glad to hear. I'd love to hear from all the board members as well. Is, if I understand correctly, is that we do want to have those new assumptions in. We're going to delay that implementation for the 2 years, but this gives 2 years for planning, as we can talk about, saying, if all our assumptions are correct and everything it stays the same, we can expect that the rates in option 2B would be the rates that we will be looking at in 2 years. Now, we know that that's not the case. Things will change, the assumption, different things, but all things being equal, then we can plan for, 2 years from now that it looks like we'll need to, because of mortality and other things that we just heard. But giving people 2 years notice on these things, I think, is perfectly appropriate.
Okay, thank you. All right, on the motion to adopt option number 1 with adopting 2B in 2017. Is that accurate?
That's accurate.
Okay. All right, on that motion, all those in favor? Are we going to do the online? Okay.
And I apologize.
it takes a while to load these motions into Novus. Please bear with us. We will be talking about your preferences about continuing to use or discontinuing use of the electronic voting during the administrative update. So you got that to look forward to during lunch. You can start to chew on that issue now. I won't guess at your vote, but here, at least now the
And David, to answer your first question, that contribution rate history is Appendix B in the report that lists it. Yeah.
The excitement is palpable. Now I know how actuaries feel. Okay, the motion carries. Is lunch ready now, or okay? So we're gonna grab lunch. It'll be about 15 minutes before we reconvene. So we'll be in recess until 12:30. We'll call the meeting back to order. As is customary, Steve gets to give his riveting administrative update while we're having lunch.
Thank you, Mr. Chair. I'll take riveting as a
compliment.
Okay, I was going to say instruction, but if you want to say, all right. Two brief topics, but before I get into that, I'd like to begin by taking this opportunity to introduce Jessie Jackson. Jessie is back working the machines there. She's the newest addition to the Left 2 board team, with Jessica promoting into the Administrative Services Manager. I hired Jessie to be my new right-hand executive assistant. She's been working at the Department of Retirement Systems in their executive unit for the past year. Prior to that, she's had experience in private sector, but her passion is her band. She is the guitarist for a very successful local band here in Olympia, Full Moon Radio, and that is that's what she would rather be doing than pensions. For the rest of you, you know what you would rather be doing, but that, for her, that's it. And she's been a great addition to the team in the time that she's been here. I feel very fortunate that she joined us. With respect to the administrative update, there are two pieces. First, SCPP update. At this point in time, there's been no response to from the SCPP regarding coordinating on any of the issues that I testified that the Left 2 board was considering in one form or another at an earlier meeting. There'll be a opportunity, I think, on the September agenda, perhaps or October agenda, to follow up on some of those. One issue, though, the board has already adopted the legislation or recommended legislation last session. It's been passed by the legislature for LEOFF, and that's this purchase of annuity. Staff has been getting a lot of questions and a lot of interest on that from LEOFF members. The SCPP is studying that applying or expanding that benefit to other plans. And so no coordination necessary in the sense that you've already got it, but just as by way of FYI, and we'll keep you up to date if anything changes and they do express any interest in working on topics such as final average salary protection for people who local government employees who experienced salary reductions in the last biennium and don't have or experience salary reductions after the expiration of the prior protection legislation, or any interest on what else, the career change or any of those types of issues that the board recommended last year that didn't pass. outreach activities, there have been a couple. Oh, David.
Just one quick question. I see on the last meeting there was a history of post-retirement employment. Was that part of the conversation at the SCPP?
Yes, that was there was sort of a background presentation of all of the different ways that post-retirement employment has been handled, where it's at now, where it was at 20 years ago. Essentially, the state has kind of come full circle to for PERS and TERS and all the other plans, almost right back to where they were. There's just one small exception. There's been a correction legislation that's been recommended by the SCPP and the Department of Retirement Systems for a couple years that has not passed. And so, but other than that, one exception, and the fact that now the higher ed plans have sort of been incorporated into the universe of plans for which there is a coordination of post-retirement employment policy. They're kind of back to the same limits on and how post-retirement employment is handled as they were 15 or 20 years ago before they started expanding. The pendulum swung, and it swung all the way back, and they walked through the history of that.
Great, thanks.
The outreach, there's been two events since we last met. Washington Council of Police and Sheriffs had their spring meeting, and the Washington State Council of Firefighters had their annual convention. Unfortunately, both organizations met on the exact same days, and they met on opposite sides of the state. So one was in Bellevue and one was in Spokane. In the past, where both organizations have met, I've tried to jump from one to the other so that they could both make a presentation at both and have an opportunity to answer questions. Given the geographical difference, this year that was impossible. So Tim presented to WACOPS and I presented to the State Council of Firefighters, or not presented, but attended their conference, answered questions that they had in their pension and their legislation subcommittees related to pension proposals that were being considered. The board did have it. We had a table at the State Council convention during that. Ryan was there as well, and so that was where we answered questions from individual members. But the materials that were provided were emailed out to you, and by way of reference, I know using the new email addresses that have been provided to all of you is sort of a change in practice. Several times when we've sent out materials, we haven't been sure that all of you have got it, and we'll work with you as I go out and I talk with each of you about your expectations. One of the things now that we'll try to follow up with is, how do you want that to handle if the current email isn't working? Because for some of you, David, you must have, you've got your email for the Left 2 board, you've got your email address for the city, you probably may have email address for other bodies on which you're a part. And so I know how that can get overwhelming. I think all of you that are active employees, active legislators, have multiple email addresses. We'll try to coordinate with you a way that works to your satisfaction, where we know you're getting the information that you want and need prior to the board meetings. One also, I previously mentioned, we just received notice from Novus that our contract for the product that they provide to us is up for renewal, and one of the add-on features to that product is the online voting. That's not a part of their standard practice. It costs $600 a year, and so I wanted to bring that issue to before you, because I know that the online voting has been At times, it hasn't gone as smooth as I know that we would like it, and I don't believe, several of you have expressed it hasn't gone as smooth as you'd like it. And so there's two options, but rather than making that kind of decision myself, I thought I would throw it out to you. Is this something you want to continue to try working on improving, or is it something that, is that a feature that you're willing to forego for the future? And I'd be happy to talk about some of the pros and cons of why it was implemented in the first place, since it was a year ago.
I think that would be beneficial so that we can make a more informed decision about how quickly we let it go.
In the past, in the past, it was rare, but occasionally there would be questions about when there was a voice vote, and the minutes were then prepared. There would be a question about how a particular member had voted or not, and the electronic voting captures that with 100% clarity. That was the primary pro. The con has been obviously that it is hasn't been quite as efficient as a voice vote, and that sometimes the voting now has taken, even if it's just a minute or two, for many of you, I know that a minute or two of silence or inactivity is, what was the word you used today? The suspense is compelling or
Palpable.
Palpable, yes. So I don't know that letting go of that suspense is something that all board members are willing to do, but
Well, looking around at legislative members here, I think having one, it's very transparent to have one's vote recorded as to who voted which way. And my recollection is that there's always a voice vote on the committees, and then you can sign how you voted afterwards. It might be just as quick to hand a clipboard around as it is to wait 2, 3, 4 minutes for the process to kind of go through. And that's not a staff issue. This is our own, like the thing times out, and then we can't get logged back in.
Yeah.
So, Jeff?
Thank you, Mr. Chair. Put things in context, 25 years ago, about 10 days before the bar exam, I had a computer hard drive that warped, and everything went away. And it was one of those existential moments that a guy remains in crisis that scars you for life, and it's gone downhill from there. And let me just say that I sincerely, absolutely, I regret and I find it distasteful to be held hostage to technology. And so I would actually stand right up here and make the motion that we go back to voice vote, and if we have to do a manual board or something, a signature on that, that we use that instead of availing ourselves of the obvious advantages of technology today.
Okay, any other comments? Does that require a motion, Steve, or is it? Do you want to record who votes in favor or against?
No, I think it was your expectations are clear. And
Thank you.
We will do our best to carry those out.
And that $50 per month can go to candy for all the board members. How's that?
That would require a separate discussion.
All right.
But with that, that concludes the administrative update. The next item, the final item on the agenda, is to discuss kind of future agenda items. We've got 4 topics on the agenda right now for the next meeting in August. One is a update on investment performance from the State Investment Board. You kind of got a little spoiler there from Lisa Wan at the State Actuary's Office. Now she didn't carry it out to 2 decimal points the way the SIB will. So you can assume that the final results are going to be in the neighborhood of 17%. It might not be 17.00, but they'll be talking about investment performance and answering your questions. And then there was a request that board just kind of do a general comparison of DB and DC plans, the features of those, and we'll be prepared to do that at the next meeting. There was some discussion about setting up a work session, and by that, this will be the first time that you guys have done that on the topic of local government participation in the state's deferred comp plan. This will be that if we do that, a work session format is not something that you've ever done before, and we'll have to try to figure out how that would be different. But the goal of it is that it is more discussion oriented amongst the board members as opposed to presentation from staff. That's tentatively on the agenda for August, and there was a request at the, I believe it was the May board meeting, to go back to move forward the issue that I mentioned earlier, the final average salary protection. That can also be, that one's ready to go at any time. Those are the issues that are currently on the agenda for August.
I'm just looking at the calendar here, Steve, and I looking at the investment board's annual update, I think they'll have a conflict on the 24th more than likely. So I believe they'll be at the CII conference.
I can't recall who from the SIB will be presenting, but you're right. It may not be Teresa or Gary as it has been in the past. But I think last year there was a similar conflict and somebody else from the SIB presented. But we'll...
Is she available on that date, she said? Okay. All right.
Kelly?
Yes.
So, have we in the past canceled our August meeting? I'm trying to think back to the last couple of years. Is that
the August meeting historically has been canceled more often than not. The select committee has canceled their August meeting. Partly, I don't know, but the Senate generally tries to free up the month of August for senators, and so the senators who sit on boards can have, that's been one thing that has also played into account. Also, for you guys, what tends to happen is you've got a lot of work that needs to be done by a deadline, July in this case, like rate adoption, and then you've got more time before December to sort of flesh out the rest of your work for the interim.
And so the question, would we be able, if we canceled the August meeting, would we have sufficient time throughout the rest of the year to accomplish the work that needs to be done, in your opinion?
In my opinion, yes. Most of the items could be moved to August. The only one I can't say for sure.
September?
September. The only one I can't say for sure as far as being rescheduled would be the SIB presentation, and that would depend on the availability of SIB staff. But I would imagine that somebody would be available at least one of the remaining meetings.
Okay. David?
So I'll make a motion that we cancel our August meeting and move as necessary, and I'll leave the staff to that about how do we, these are all great topics for our discussion, and I think I like the idea of a work session, but if we can move that and throughout our work plan over the next, I'll leave it to staff how long, but that'd be my motion.
Is there a second?
Second.
Moved and seconded. Further discussion? Okay, seeing none, all those in favor of the motion, please signify by saying aye.
Aye.
Those opposed, no.
That
The
took us
record will
about
have to
3
show
seconds for that
everybody
vote
voted.
here. So.
Yeah. Okay. Jack?
I'd like to see the board give us some more information on excess compensation and career extension. I think both of those warrant some additional information, and maybe head off some things in legislature that we may not like.
Okay.
Can you just expand on those two items? I just want to make sure I'm understanding what the issue.
The excess compensation bill was the one that was run, I think it's run the last couple of years, where overtime, big part of the retirement for the last final average salary. And the other's the extension, career extension, guys that end up retiring and taking on another job with public safety, having the option to do that or the opportunity to do that and not be penalized. Also isolate the state from additional contributions or responsibilities.
The excess compensation issue was also raised by Representative Holy at the last meeting, and so at the direction of the board, we've been working on that issue somewhat, and I think we'll be prepared to bring back some preliminary, or at least what we found so far at the September meeting. Career extension issue is sort of, as I understand it, this is sort of the carry forward of the career change fix that started last year, but brought up additional issues such as the people, the inability to recruit, for instance, chiefs, if they are in-state retirees without it affecting their pension.
Kevin, then David.
Could you tell me the dates of the last 4 meetings for the rest of the year real fast? Can we go over that?
Yes. September 24th, October 22nd will be the off-site to discuss expectations and strategic planning. November 29th and December 17th.
November 29th is a Saturday?
Oh, November 19th.
19th, okay. And then what was the December one?
December 17th.
Thank you.
I need new contacts, apparently. Sorry about that.
David?
Oh, I was just following up on Jack's comments. It would be useful to, because I thought we had done both of those comments, excess compensation and the career extension or career change. So I don't want to, if there's new information or additional reports, because I thought we had done both of those items. I thought, just my memory was excess compensation is that we found out that there wasn't, is that the salary spiking at the end, that we didn't see that to be really a big issue for our left 2 members. And career extension, I think we had a fairly healthy debate about that and took action. So I just want to make sure if there's actions that are before the board, then if there's more information to be had. But I don't want to keep going back to the same issues on our agendas each time.
That's fair. With respect to the excess comp issue, at the last meeting, Representative Holy brought forward some new information and some new concerns, and was trying to find out, asked staff to find out to what extent is more current information available on this issue. As you'll recall, the prior study was done by the Washington State Institute for Public Policy, and they had used sort of a 5-year look back on people's AFCs, and the concern was that maybe that had missed some trends that might be developing as a result of the current economic pressures that weren't present, say, 3 to 8 years ago, but are present now. And also the Institute for Public Policy had a difficulty getting at local government data, and so most of their findings were a result of the state employee database, which for public safety employees is fairly limited. So those are that we've been trying to do some figure out what, if any, more current available data is available, and does that information demonstrate any trends? With respect to the career change fix issue, the question about the issue was discussed in terms of what some of the objections to that board legislation were during session, and the board, but there was no action taken either affirmatively or negatively. So that issue has languished, I would say, as opposed to having been voted on one way or another in terms of, do you want to push forward the same bill again? Do you want to try to push forward a different bill, or do you want to just not do anything? As I understood Jack's comment, you're interested in looking, you're trying to see if, are there any other options out there that could address some of those concerns that were raised during session, particularly the one related to LEOFF employees returning to work in LEOFF positions for other employers. And we could certainly try to develop what kind of options might be available policy-wise, but that would take a motion of the board to get that on, added to a future agenda.
I make the motion.
I'll second it.
Moved and seconded. Discussion on the topic of bringing career change back for some renewed discussion. Okay.
Just some discussion. It's always good to be talking about these things. I know it's impacting not just our public safety officers, but other people. We're finding out that, at least in the city family, that people who have financial or accounting backgrounds are also being harmed by how the DRS is narrowly defining what people can do when they're retired. So I'd be interested in looking at several options, but I mean, it's going to be a constant continuing debate that we have here. So more information and more options. I'm open to those things. Yeah.
Okay. Further discussion? Seeing none, all those in favor of the motion, please signify by saying aye.
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 Those opposed, no. All right. That motion carries. Maybe we could do a hand vote. Show of hands.
No, that cannot be captured for purposes of the minutes.
Okay. All right.
But in the event that there is any lack of clarity at the time a vote is done, a roll call vote is certainly one way to provide clarity. And what we currently do is we capture the votes in the minutes, and then if there's a discrepancy, that's an opportunity for board members to correct any mistakes.
We have experience with roll call votes. Okay. Any other items for agenda items for future meetings? Okay. Seeing none, that concludes the agenda before us. Are there any other items to come before the board? Okay. Seeing no one rushing up to the microphone, we will be adjourned until September 24th. Thank you, everybody. Safe travels.